Thank you for the invitation, and thank you, Professor Szilágyi, because you gave me a special mission yesterday to be at a conference which is not dedicated to any topic of law, but to the topic which is, fortunately or unfortunately, the topic of today and the future, the artificial intelligence. But the consequences and the relations with this topic and the law will be very important in the future, because maybe the artificial intelligence is important today and in future, but the law is always important, and as one says, the law is above all, because we are all talking about the rule of law. If it is not like that, we won't have that title of our conference, the interpretation of the rule of law in Central Europe in light of the supranational concept of the rule of law. And my topic will be related to the judicial reform in Serbia, but in the light of the Venetian concept of the rule of law, and because of that, and not only because of that, I am wearing this tie with lions. Not only because of that, because also of the Central Academy, European Academy. So I have to be prepared with my style to be the part, I think, important part of this team. And I congratulate you for the organization of this event, and I'm very glad to see good rooms, good areas for work and the conference. I think that you really have a future, but of course you really have the future because you gather together important, relatively young and motivated, of course young, and us relatively young and motivated experts to cooperate with you and to be I think the important component and important actors in your team. So my topic is the judicial reform in Serbia in the light of the Venetian concept of the rule of law. And the first part of my article is related to some constitutional traces of the two important principles of judicial independence and of course the rule of law in the constitutional history of Serbia. As you can see here, the first modern constitution in Serbia, the Sretenje constitution from 1835, proclaimed the independence of the judiciary, but the classic determination of the independence of the judiciary is expressly defined in a very important constitutional act in Serbia from the 19th century, the Constitution of Kingdom of Serbia from 1888. And after that, the first Yugoslav constitution, the Vidovdan constitution from 1921, also contains strong formal guarantees of judicial independence. Of course, all those guarantees were mostly in the paper, not in the reality, but for those days, for that period of time, it was rather very important. And as we are talking about the rule of law, the principle of the rule of law is in the Serbian constitutional law related or linked to the recent constitutional history and to the Constitution of Serbia from 1990. Maybe it is only a coincidence, but of course it is not a coincidence, because in the history and in life the coincidences are only marginal phenomena. Always there are some related links, but in 1990 the important international body, the body of the Council of Europe, the Venice Commission, came into force, and with the primary text to help former real socialist countries in bringing new constitution in resting on three pillars: the rule of law, democracy, and human rights. The first constitution which proclaimed the rule of law principles in the Serbian constitutional law was the constitution of 1990. Unfortunately, it was a chimera because of the period of time in Serbia with a lot of difficulties in Serbian society and around Serbia. In that period, also the Federal Republic of Yugoslavia. I mean, and you, I think that you all know the wars surrounding our territory, and it reflected to development of our legal and political system. And the constitution from 2006 can be roughly described as a corrected constitution from 1999, partly for the better and much more for the worse. This particularly applies to the provision on judiciary. Although a formally independent body, the High Judicial Council of the Judiciary was established, but the National Assembly continued to elect judges who were being elected to office for the first time. The permanency of the judges' function was curtailed by the probation mandate of judges who were elected for the first time for a period of 3 years, but also by the deconstitutionalization of the grounds and reasons for the termination of judicial office. After that, I cannot describe that process in detail, but we had in Serbia a very tough, very tough judicial reform with a lot of negative consequences which was made in our judiciary. And as one professor from Serbia said, that this so-called reform of the judiciary from a period of 2008 to 2010 led to a state of confusion in the Serbian judiciary. After a period of relaxation, Serbia was on the path, or constitutional path, of reforming judiciary with one primary goal to completely or relatively completely made the judiciary depoliticized, more efficient, more responsible, and of course more independent. And the need for the help and the assistance of the Venice Commission was obvious. So one of the documents which were very important in that process, which was the point of reference and kind of control mechanisms to check if proposed solutions are in accordance with international, especially Venetian standards, was, you may hear of that document. It is the VC, Rule of Law Checklist. Rule of Law Checklist. I called that document an identity card and a constitutional document of the Venice Commission in the sphere of the rule of law. This document represents a synthesis of the multi-decade contribution of the Commission to the definition and implementation of the modern concept of the rule of law. And this document defines several benchmarks of the modern concept of the rule of law: legality, legal certainty, prevention of abuse or misuse of powers, equality before the law and non-discrimination, and access to justice. Of course, for this topic, for the judicial reform, the access to justice is of the special importance. And in Serbia, I have to read the introductory part in a way I see our path, our constitutional path in reform of judiciary. If we are locating somewhere near St. Marco Square, Piazza San Marco, the most popular tourist location in Venice, to get to the Scuola Grande San Giovanni Evangelista, which houses the seat of the Venice Commission, where the plenary sessions are regularly held, if we have to cross the famous Rialto Bridge, Ponte di Rialto. We are on the bridge somewhere exactly half away to final destinations. Since Serbia established formal cooperation with the Venice Commission in 2001, of course then as a former socialist republic, Federal Republic of Yugoslavia, Serbia, in a way, needs to go through the Venetian labyrinths, and it took her 2 decades to find and finally cross the Rialto Bridge. And the influence of the Venice Commission was very limited until 2021. Then began the process of constitutional reform of judiciary. I can say with a very precise and definite goal to finally have this constitutional reform, because in the previous years there was a lot of problems. We were often talking about this process, about this constitutional reform, but nothing especially or concretely were done. So I don't want to describe here in oral presentation. You have that in my paper, the details of that process, but I must highlight 2 important achievements of that process. The first important achievement of the process of amending the Constitution in 2021 was a public hearing which included a wide range of interesting subjects, as well as the formation of a representative working group of the drafting of constitutional amendments. It is not because I led that group, informally, not formally, because as a professor of constitutional law and judge of the Constitutional Court, you don't have a mandate to be in a way on a political position, but not because I led that process. I really, with my colleagues, with my associate from Scientific Institute for Comparative Law in Belgrade, I really gained the main purpose, the main goal of our participation in that process. We managed to implement some international and also constitutional standards of our constitutional law in the solutions, in the constitutional solutions. So, in the opinion of the Venice Commission, the whole process, as well as the result of the process, were very positively assessed. Of course, it was positively assessed by the most important organizations in Serbia, legal organizations, the Supreme Court, the High Judicial Council of Judiciary, the Society of Judiciary, Serbian Society of Judiciary, etc. But on the other hand, there were some subjects which were not enough satisfied with these reforms, and that's a normal thing. So it was a real public. I think that it was a real public hearing in circumstances that that Serbia has today. And the second important standard is a qualitative shift in cooperation with the Venice Commission. The Commission was actively present and openly meets consulted in order to reach not only a positive opinion of this body, but a higher quality text that meets international standards of the rule of law. Sorry, I didn't change the slide, but I told you about that, I think, yes, about the checklist, and then about the reform of the judiciary in Serbia. So you have some steps of the most important steps of that reform, which was concluding with the revision of the Constitution proclaimed on February 19, 2022. Before that, we had the approval of the constitutional amendment by the citizens in the referendum on January the 16th. I have to say that this referendum was successful, but from the standpoint of democratic legitimacy, I must be honest with you, the turnout was low. This was the period immediately after the COVID era. So in general, maybe more citizens should have come to the poll and give their voice against or for the referendum, but in the conclusion, the referendum succeeded and the constitutional amendment gained into force. And after that, the judicial laws was adopted a year later, and it is also a good thing because in Serbia usually we are late. Sometimes we are late. We are late even for decades. The whole process of transition was very slow. And comparing to Hungary, I don't have it in the paper, but sometimes you have to react at the spot. Comparing to Hungary, I think that our transition process from the 90s was a little bit slow with a lot of obstacles, and that unfortunately our transition is yet to come at a higher spot, and we are trying to find our place in the world of the states with the rule of law and especially the independence of the judiciary. Not to be with a lot of details in my presentation, I will tell you that, as you can see, the constitutional amendments made, in my opinion, 4 systematic changes. The first systematic change was the return of the permanency of the judicial office as an absolute constitutional principle, because before the constitutional amendment we had so-called probationary mandate of judges. They were elected for a period of 3 years, and they were elected by the National Assembly, and it was a very bad solution from the point of the independence of the judiciary. And the second systematic change was the method of electing judges. After many periods of time, finally the High Judicial Council is competent for the election of all judges to a permanent position. And the third systematic change is the IGC as a constitutionally potent body. I mean that this body got the very important competencies relating to deciding on the position of judges, president of courts and lay judges specified in the Constitution, and that was specified in the constitutions, but other competencies of this body, which are also very important, are defined by the law on judges. You can see very briefly here what is the new membership of the IGC. We have a relatively balanced structure of the IGC: 6 judges elected by the judges, 4 prominent lawyers elected by the National Assembly, and the president of the Supreme Court. I just have to highlight that in the opinion of the Venice Commission, the president of the Supreme Court should not be, or it is not in contradiction with their standards, but they suggested to leave the president of the Supreme Court at house, not to be the member of the High Judicial Council, but our state was very firm about its presence, not as a president of the High Judicial Council, but as an ordinary member of the High Judicial Council. And I can say a lot about those category of prominent lawyers. Unfortunately, we are searching the prominent lawyers, and I think that the election process in the next 10 years we have to improve it, especially from the point of transparency and from the point of responsibility of state organs, and also of our Serbian experts who will be more motivated to be a candidate, because if the candidates are generally not the prominent lawyers, the selections which is given from the parliamentary assembly, parliamentary committee, and afterwards by the National Assembly election is of course very restricted, and with some I can say with some deficiency. And because of that, in the implementation process, we have some problems a lot of people think that there are not many prominent lawyers in the high GC in the first mandate of the high GC. And the fourth systematic change was the stronger guarantees of internal independence of the public prosecution and abolition of the category of deputy public prosecutors. What the Venice Commission said in October 2022, they of course positively assessed the normative framework, I mean the constitutional amendments and legislative amendments, but of course they identified four key challenges to the further process of judiciary reform. As you can see, the first one is generation gap between judges. We in Serbia have a lot of old judges. They are prepared to go to the pension, to the retirement, and unfortunately the law students and the graduated students are not motivated a lot to become judges. One of the reasons is the second point, the material conditions for performing the function of a judge. Maybe the third one is also relevant, the strictly hierarchical organization of the judiciary with a strong notion of supervision, hierarchy between higher courts and lower courts, etc. And of course, what is the most important thing and what is the difficultest achievement from all the states who are searching, who are trying to improve their rule of law conditions, is the change and the building of the rule of law legal culture. So in the conclusion, I think that several factors of success are very relevant. Of course, always is the time. In my prediction, it is at least 10 years for settle this new system and to see if there are some weak spots in that system. Then the involvement and dedicated work of all stakeholders in the process and the responsibility of everyone, especially of the judicial councils, because that institution was very compromised in Serbia in the previous period, before the constitutional amendments of 2022. And of course, very important is ability and responsibility to solve problems, not to Photoshop them. In the very last sentence in my paper, as you can see, is that the reform of the judiciary in the Venetian mirror will remain like the Vain Queen from the fairy tale about Snow White and the Seven Dwarfs. If its bearers do not take a good look at the Serbian political and legal mirror and the vision of universal justice, which is the only and true rule of law. What does it mean? It means that international standards are very important. We must follow them, we must implement them. But national constitutional, legal and political identity is even more important. It is something which should be in the path of international standards, but international standards are here to be modified in accordance with national circumstances. Thank you. I hope that I was not too long.